ground to cover today, but I do hope that we have some time for questions at the end of the program. If you have any questions, please click on the chat button at the bottom of the screen and then type your question into the chat box. Our production staff will be monitoring the chat room for your questions and your comments. Also note that we are also taping this program. We will post it to the MBA's YouTube channel. So if there's somebody at the bank that doesn't have the opportunity to watch this program live today, let them know that it will be available for them to view later on. The program should be posted within a couple days. My guest today is Matthew Bialick. Matthew is the managing member of MJB Law Firm PLLC, a boutique banking law firm located in Chanhassen. Welcome, Matthew. It's a pleasure to have you on the show, and it's great to see you this morning.
Yeah, thank you so much for having me. I always have a lot of fun with these things.
Absolutely.
I love the MBA.
Absolutely. That's great to hear. Before we get rolling with today's topic, I want to give you an update on another MBA matter. You all remember that the MBA filed a lawsuit against the FDIC, alleging that the agency's rule on represented checks violated the Federal Administrative Procedure Act. That important law governs the regulatory agency's operations. The FDIC responded to our lawsuit by filing a motion to dismiss, which is a fairly typical response. Most of the FDIC's reasons for asking for that motion to dismiss were procedural. Recently, we received the shocking news that the judge decided to grant the FDIC's motion to dismiss. That result was totally unexpected because we thought we had done a great job with the complaint and had appropriately answered the FDIC's arguments to their motion to dismiss. The judge dismissed the case for one of the technical reasons, which was that the judge thought we did not have standing to sue the FDIC. While the judge's decision to dismiss the case was awful news, there was one silver lining. The judge dismissed the case without prejudice. A case can either be dismissed with prejudice or without prejudice. A case dismissed with prejudice is basically done, but a case dismissed without prejudice leaves the plaintiffs with some options. A dismissal without prejudice is relatively rare, and it usually happens in cases like this one, where there is a technical or procedural problem. The plaintiffs then have the option to fix the technical problem and refile their lawsuit because the judge never really got to the merits of the case. We are currently evaluating our options with our outside counsel. It looks like at this point, we have three options. Number one, we could appeal this judge's order to dismiss the case to the Court of Appeals. Number two, we could correct the technical problems and refile the suit. Or number three, we could do nothing, which would mean that our case is over at this point. We've got some tough decisions to make there, but we're going to truly analyze all of our options and see what we're going to do. Once we have made that decision, we will let you know what we're doing. All right. So with that said, let's get started on our program here today with our guest. Welcome again, Matthew. Thank you again for joining me. I've had the chance to get to know you over the years because you have worked with the MBA on some agricultural law issues, and also you've taught some of our classes on commercial and agricultural liquidations and bankruptcies. But for our guests online here today, can you please tell our viewers a little bit about yourself, like where you grew up, where you went to school, and why you chose to become a lawyer?
Certainly, so happy to get into it. So again, my name is Matt Bialick. I'm an attorney. I'm 39 years old. I'm married. I have two young daughters that are absolutely the light of my world, 2 years old and 6 months old. So between that and running my own law firm, you better believe that life is a little bit hectic right now, but in the very best way. So I grew up on the, in the east side of Minnetonka, not on the lake. It's a pretty easy answer why I became an attorney. My dad is an attorney, a small firm owner. He's a longtime small firm owner. Now he's an administrative law judge. And I like to jokingly / not so jokingly say I never really had a choice in the matter. I heard, in my childhood, it was all about hearing, how great it is to be a lawyer, all you can do to protect yourself, what the legal system can bring. And, I listened. Growing up, I went to Hopkins High School. I was part of the far lesser known dynasty there, which was cross country running. Equally much of a dynasty because we ended up winning the state championships 3 out of 4 years that I was there. Can't say that I had that much to do with that personally, but it was a great experience. It taught me a wonderful work ethic. Then I went to business school at the U of M, and then I went to law school at the U of M, and have been practicing law for 15 years now. I've owned my own law firm for 5, and the rest is history, I guess.
Well, that's fantastic. Thanks for filling in those details. And I'm a dad of 2 daughters too. I don't know if you knew that. Mine are on the other end of the scale. My wife and I became empty nesters for the first time with both our kids off to college. So everybody gives you this advice, but remember to enjoy every phase of it as you're going along, because all of a sudden you're going to be sitting in a chair telling everybody that your kids are off to college.
I know it's amazing, even at this point, how fast it's gone.
Yeah, absolutely. So thank you for that. I really appreciate it. There are a lot of different areas of focus under the broad umbrella of banking law. What are the areas of banking law that have become the focus of your practice, and how did you first start practicing in those particular areas?
Certainly. So I first became a lawyer in 2008, looking for my first professional job. Horrible time to be doing that, but there was a lot going on in the workout space. For my first few years of practice, I just worked for a public law firm doing general practice work. Great place to learn the nuts and bolts of being an attorney. And then 3.5 years in, or 4 years in, I got my start in banking law. I moved over to a small boutique banking law firm. I remember pretty much my first day that I was there, I was asked, well, have you done any workout work before? And the answer was no. And the response was, okay, here's the entire workout portfolio of a failed bank. Go. And so it was very much sink or swim. And I was able to swim. I was able to learn a lot. Because at that point we were on the tail end of the 2008 financial crisis. A lot of the files that were in the firm were less routine workout files, things where there was a fraud component, there was a conversion component, successor and interest type issues. And so a lot of it was more off the beaten path. And so a lot of what I was doing was less of the just cranking out foreclosures and more unwinding voidable transfers, finding the money, and as it were. So that's kind of how I developed my sub focus, which what I would say would be undersecured agricultural and commercial collections. And by that, I mean, so this isn't consumer, this isn't unsecured collections. This is a scenario where the bank has security, but either through borrower misconduct or a devaluation of assets or economic changes, find itself in an undersecured or even badly undersecured scenario. Right. And then realizes we need to do something drastic, otherwise we're going to take a major loss. So that kind of became my sub focus starting in the early 2010s. And then as the farm crisis hit in the mid-late 2010s, yes, a lot of clients were coming to me and saying, okay, well, can you help us on our agricultural loans? And so I got myself fully up to speed with the statutory regulatory framework in the agricultural space. And what I found very quickly is it gelled very well with my undersecured collections background. Sure. Because I think it's interesting that most people think that ag and ag liquidations are so unique because of the statutory framework, but that's not it. What it is because ag tends to be a way of life. When these things go into liquidation, there tends to be this attitude of we're going to avoid the foreclosure, we're going to avoid losing the farm at all costs. Right. And so there's a lot of conversion, a lot of voidable transfers. And so in order to be made whole, banks tend to have to get a little bit creative. They have to go towards third-party recipients, whether that be family members, other creditors, or in the case of what we're going to be talking about here today, parties like grain buyers.
Sure, absolutely. That's fascinating. There are all those different avenues you can go down, but you've found a heck of a niche. And I know from teaching our courses that you really are an expert in these areas. So it's always fun to talk to an expert. So the MBA provides a wide range of advocacy services to our member banks. We lobby in St. Paul, we lobby in DC. We try and provide a good regulatory framework for banks, and that's been really challenging for us these days because the agencies are just going crazy with regulations. In addition to those types of advocacy, we do a kind of specialized one, which is our legal team is able to file amicus briefs in lawsuits that involve our banks. An amicus curiae it means friend of the court, and it allows a non-party to the lawsuit to file a brief and expand on why the case might be important, not only for the parties that are involved, but in our case, not just the bank involved, but the entire industry. And so this is something we've done in the past, and it's a good service that we can provide by way of advocacy, because just like the legislature can make a bad law, the courts can give a bad decision that ends up impacting not only that one bank, but the whole industry. So it's something that we're proud to be able to offer. So you had contacted the MBA with respect to a case that you were in involving one of our member banks. Maybe you could tell us a little bit about the facts of that case and why you came to us, maybe looking for a little assistance from us on the industry side of things.
Certainly. So this is a case dealing with grain fronting. And it's easy to hear that term and think, well, that's not something we've ever dealt with. Actually, it's something you may have dealt with and just may not realize that that's what it is. So this case started out just like any agricultural workout liquidation, a series of agricultural loans to a family farming operation. The one that's most relevant here is an operating line that was past due. The bank was amazing in working with their customer, trying to, find whatever avenues that it could, but ultimately it got to the point where it had to start verifying that, hey, is the collateral there? And the request for an inspection of the crop was denied, which tends to be one thing, and warning bells go off at that point. And so it went through farmer lender mediation without resolution, and then essentially going through traditional liquidation process. But the central question was not, hey, getting the real estate foreclosed or, whatnot. It's where's the grain? Because millions of dollars worth of grain went missing. So trying to figure that out. And it involved one lawsuit. Then through that lawsuit, we were able to figure out what had happened. And essentially the grain was liquidated through a variety of family members in order to circumvent the CNS filing, with the proceeds funneled between the different family members. In ag liquidations, there tends to be kind of a standard game plan that I'll see in a lot of them, which is basically hang the debt on the senior member of the prior generation, but try to funnel assets and operations to the next generation. And that's what we were dealing with here. And so after we unwound exactly what happened, we had to bring a second lawsuit, a series of avoidable transfer lawsuits against relatives, and also some claims against grain buyers who purchased this grain. One thing that a lot of banks don't know, well, one thing a lot of banks do know is that the CNS financing system will provide protection. And if the buyer ignores the financing statement and issues a check not in the bank's name and they don't get paid, that they have legal recourse. But what a lot of banks don't know is that there's also recourse, and it's actually strict liability recourse in a fronting scenario. And fronting is essentially just that you're selling the grain in the name of someone who didn't grow it in order to circumvent the CNS fine. So one of the grain buyers that was involved in the lawsuit decided that they thought that the law was wrong, and they primarily defended on that basis, which isn't something that tends to go over very well at the district court level. They were ultimately unsuccessful, and we were successful in getting summary judgment against them. And they made good on their threat to appeal. Now, at that point, I reached out to you and the MBA for a couple reasons. The main reason was that there was a concern that grain buyers and some of the large players in the lobby could look at this as their opportunity to, get the law changed.
Right.
And we had a concern that they were going to step in and file amicus briefs of their own. And then if we didn't have a large, influential trade organization behind us, we were concerned that the Court of Appeals would see all of this support on the grain side and hear all these arguments of why the law is wrong, and we would have basically nothing to back it up. So that's the first reason. And the second reason is just the Court of Appeals occasionally can have a habit of not reversing cases head on, but instead just carving out a fact-specific scenario in a way that can undermine the legal holding. And so we just wanted to make it clear that, hey, this is a really important issue. This is a really important case. It's not just a one-off scenario. We've got some large players looking at it. And so we wanted to send that message. And so I made the request and was thrilled that you decided to jump in and help.
Yeah. And so on our side of that equation, when we get that request, we have to get board approval for appearing in any of these cases. The board wants to know that we are getting involved not just to help one single bank, but to help the whole industry. So Tess and I analyzed the facts, analyzed the law, and realized that this was a really important case to make sure that there isn't any of that. There isn't going to be, first of all, a wholesale change in the existing court precedent, and then secondly, that we didn't even want them to chip away at it. What we have right now is a clear victory in these cases, and that's what we wanted to maintain. So we are pleased to be able to jump in. So that's good background on the facts of what we saw happening, but maybe you could talk a little bit deeper about the law that we're talking about, because the way we looked at this, and as we talked about it as I was preparing our brief, the law is crystal clear who wins. And the Minnesota Supreme Court case is crystal clear on who wins. So maybe you can get into some of it a little deeper on that side of it.
Sure. I'll touch on the law and why I think it's important to banks, even if you haven't realized why it's important. So essentially, I think most bankers are going to know in the ag space that the CNS financing system is very, very important. But there's some flaws. There's some weaknesses in the system, which is that it can be circumvented in about as many ways as it can be applicable. Either, a buyer or a borrower can sell in a different state and circumvent it, or probably more commonly than you might think, that they just sell in the name of a family member. So essentially, I think some banks maybe improperly realize, okay, well, that fraud occurred. Yeah, we can go after the family member, but there's nothing we can really do about the buyer. But in 2006 Supreme Court case, Finag v. Huffnagel, the Supreme Court, the Minnesota Supreme Court, took a look at the issue of, okay, well, what happens if it was sold in the name of a third party? And they didn't get into the mushy issue of who should win or what's fair, because there's an argument that there's going to be some unfairness that's going to result one way or another. I mean, assume this is a scenario where the bank did everything it was supposed to. It filed the CNS financing statement. Assume even that the grain buyer was diligent and did their due diligence on the grain that they were purchasing. Somebody is going to suffer a loss here. Right. And what the Supreme Court ultimately decided is, we're not the legislature. We're not going to say who we think it's fair or unfair for a loss to fall on. We're going to look at the operative statutory authority and we're going to interpret it consistent with it. And what we're dealing with here is a few different pieces of authority. One is the UCC and the general rule that, a security interest is going to follow a sale of products. Then there's the next step, which is the buyer in the ordinary course of business exception, which is saying, well, hey, if I'm a buyer in the ordinary course of business, then I don't take subject to the security interest. But there's two limitations to that. One is the fact that agricultural products are carved out of that exception. And two, that there's language that was really important in the case. Well, a buyer takes free of a security interest created by the seller.
Right.
And in the case of a fronting scenario or fraud scenario, the party who's selling it didn't create the security interest. So that was a big part of it. And then there was also the Food Security Act of 1985, because initially the backdrop was when the farm product exception came into play, a lot of grain buyers were taking this grain, getting subject to lawsuits, and they're saying, hey, we had no way of even knowing what was going on in this.
Right.
And so Congress enacted legislation that provided parameters around, certain security interests that the buyers do and do not take subject to.
Right.
And they created the operative legislation, which gave rise to the CNS financing system. And so essentially the Food Security Act, despite the fact that it gives notice to these grain buyers, has the same limitations as the UCC, which is it does not provide protection for security interests created by somebody other than the seller. And so the court looked at those two things and said, well, in this case, one of two things has to be true. Either the seller is the secret undisclosed seller who really grew the product, in which case bank filed a CNS financing statement. So buyer took subject to that security interest, or the seller was this fronting party and they didn't create the security interest. And so therefore, the buyer still took subject to it. So essentially what it created is it created a strict liability standard where if grain buyers buy fronted grain, they're liable to the bank, whether they knew, didn't know, did something wrong, anything like that. And that, in this case, that was the legal authority we were protecting. And it goes well beyond just this case.
Right.
It's any bank that's dealing with a grain fronting scenario can use this legal authority. So if Huffnagel got reversed, or if it's a scenario where they whittled down the facts or created such a situation that it functionally, eviscerated it,
Right.
it would hurt every bank in the state.
Right. And anytime you have a strict liability standard like that, it's a tough situation. And what it does for the grain buyers, this is part of our argument and our side of it, and yours as well. Grain buyers, it's a buyer beware type situation. You have to get the correct seller or you will be liable for purchasing that grain. That's the current standard. And that's what we want to make sure that we keep in place, because anything less than that, and it's going to shift the liability. So it really is a great result that we currently have under the law. So again, the buyers of the grain appealed. We just had the hearing last week, I think it was, at the appeals court level. How do you think that went?
I think it went really well. I was very pleased that very early on, the judges in their questioning had basically said, assume we don't overturn Huffnagel, kind of now let's talk.
Yeah.
Which of course you can't. I always say don't read tea leaves at the Court of Appeals, don't read tea leaves based on questions, but I think it's a good sign that the Court of Appeals is saying we're not going to touch, this case applies, we're not going to touch it.
Right.
And it became about more mundane appeal issues, whether there were fact questions or not, which in a lot of ways is very important too. The fact questions we're talking about is, did you prove with enough certainty who owns the grain in a scenario where there's a bunch of family members, there's commingling, and that actually is very important to protect as well.
Right.
Because if it's a scenario where the court takes too strict of a view of you have to down to the kernel,
Right.
no doubt whatsoever, prove what's going on. It could be a scenario that can destroy summary judgment for banks and could make it way harder to do anything with it.
Yeah, I think that would be a terrible result, because right now, all of the impetus is on the buyer to get it right, who the seller is. And if they mess around too much with the bank side having to prove the exact ownership of all those kernels of grain, it really does whittle away at that thing. Right now, if you're not right on the buyer side, you're wrong, and that's a great standard for us. So assuming the appeals court, says that the district court got it right, what do you think would be the next step then?
So the next step would be, which I would be expecting, would be that the defendant would seek Supreme Court review. In Minnesota, it's not, you can get review by the Supreme Court, but it's not review as a matter of right. You have to submit a petition. The Supreme Court has complete discretion as to whether they do or don't take it. The bare numbers, I think, are about 10% of the requests are accepted.
Sure.
So it's unlikely in a vacuum that the review would be taken. But if it isn't taken, then not only is Huffnagel stand, but now there's an additional Court of Appeals case that's more recent that's saying, hey, doesn't matter that it's 20 years old. This is the law of the land, which would be phenomenal. Or the alternative is that it is taken, in which case the parties would make their arguments. And now it's not, you just assume Huffnagel is going to stay.
Right.
It's everything. It's, the gloves are off. You're talking about policy. You're talking about statutory interpretation.
Yeah.
And at that point, I think the statistics are, it's about a 50-50 shot of reversal. So it doesn't mean they're going to reverse it. It doesn't mean they're going to uphold it.
Yeah.
But it's a whole new ball game. But I would find it unlikely, but certainly possible.
Yeah, and the Supreme Court would be the one to do that. It wouldn't be this appeals court.
It would not. It would be the Supreme Court. Correct.
All right. So for the banks that are listening to this program and are engaged in agricultural lending, what would you say are kind of the biggest takeaways from this case as far as actionable items that they can do?
Okay. So there's two components to it. There's a backwards looking component to it and a forwards looking component to it.
Sure.
The forwards looking component is probably more accessible, just in the sense of it highlights the importance of the CNS financing system, because it shows a grain fronting lawsuit is a lawsuit against a solvent entity with a strict liability standard. It's maybe the most powerful collection tool I've ever seen in my entire career. Okay. And that's what's saying that the CNS filing matters. It matters a lot because it could give you real recourse that actually means something. And so if you're thinking, well, they could just circumvent it and so why does it matter as much? Yeah. It really matters.
Right.
And so doing your due diligence, making sure the CNS is filed, getting a handle on any grain sales that are taking place in other states, because right. This is Minnesota specific.
Right.
So I think, and also not being cavalier about waiving CNS rights. Direct deposit is a big problem. And that's why don't waive your CNS rights through direct deposit authorizations. But so anyways, that's kind of the forward looking. And also, if this happens to you in the future, know that you have this area of recourse. But one thing that I think is very significant, probably even more significant, is going to be the backwards looking component. It's very easy to say, well, this is very interesting, or if it comes up in the future, we can do something about it. Based on my interpretation and research on it, there's a 6-year statute of limitations on this type of cause of action, right. Which means if your bank suffered a loss in an agricultural file anytime within the last 6 years under a scenario where you suspected that grain went missing, you can do something about it. You can do something about it today. And these tend to be large claims against very solvent entities. So, and these types of claims, from my research, would survive a Chapter 12 bankruptcy. They would survive the completion of a traditional agricultural liquidation. It's possible that there could even be some residual rights in some kind of debt sale or a negotiated payment. So sure. Critically important, there could be hundreds of thousands or millions of dollars still on the table. And if the bank's in a position where they're thinking, God, I have a file like that. This is a scenario I've dealt with, but it was big, it was messy, it was ugly. I don't really want to open the door again. I know at least one debt buyer who's very interested in buying these types of residual claims. So, if you can answer the question, you suffered a loss on an ag file in the last 6 years, in a scenario where commodities look like they went missing, you really should be looking into it. And one thing that I think I should be clear on too is we're talking about grain. It's not limited to grain.
Right.
It's any agricultural commodities, any
Right.
farm product. So, we're talking cattle, livestock, anything like that. So this is phenomenally important stuff. This is not just an academic discussion that, well, this is interesting. I mean, this is a way that banks can tangibly get recovery, even on a file where they thought they just suffered a loss and had to lick their wounds and move on. I mean, there's still something you can do about it.
Absolutely. And I do see that we have a question in the chat.
Yeah. How would a buyer verify who was the actual seller of the grain?
I'll just repeat that and make sure you have it. Say it again.
How would a buyer verify who is the actual seller of the grain?
Oh, great question. How does the buyer verify who's the seller?
Sure. And that's one of the things that we went into in the appeal. And I mean, there's a narrow answer and a slightly different answer. The narrow answer is, for the purpose of the claim, it's legally irrelevant. It seems like it's the most relevant question because it's unfair, but based on the nature of how the law works, they could have done, a multi-hour interview, due diligence, going down to the farm. That would provide zero protection legally. But from a practical perspective, and I know that the MBA went into this a little bit, and maybe I'll let you take this portion of it. It's the know your buyer.
Yeah. So the grain buyer made a statement in their briefs that said there was no feasible way for them to identify who is the real seller of the grain. But this was we were talking about an ethanol plant. So over a period of time, multiple trucks pulled up to this place. And in each of those cases, the driver of the truck said, "I am the rightful seller." Well, that may or may not be true, but they did absolutely nothing to verify it. When there was no CNS filing for this person, rather than doing some additional digging and trying to figure out why there wasn't a filing, they just kept writing checks. So our argument was, when you know you're strictly liable, if you get that part wrong, you should have procedures in place to get it right. So and especially if you have the red flag of no CNS filing, that doesn't happen very often. A very, very high percentage, 90% plus, is probably covered by a CNS filing. So when you get one of those that's not covered, and you're buying like $500,000 of grain from that person, when you know you're liable if you get it wrong, I would think that they could come up with some procedures to make sure they get it right. And do a farm inspection. Ask basic questions. Where do you farm? How many acres? How much grain do you have left to sell? Are we going to see you again? All those questions would at least get the purported seller, the fraudulent seller, to at least make some statements and at least give you some answers.
Yeah, and in this case, actually, so this was sold by the fronting seller was the nephew of the party who grew and actually owned the grain. And interestingly enough, he took his uncle's trucks to the ethanol plant to sell it. And they recorded the owner of the trucks on every single document and sales document. So the true owner is listed on every document. So running a CNS search on the name that pops up there. I mean, this is not something that's, I mean, in theory, it could be unascertainable, but in practice, I find, and I've done a number of these cases, that there's a way to know.
Yeah, for sure. All right. Well, I see we're bumping up against our time. Thank you to all of you for participating in this program. Matthew, thank you so much. It was a pleasure to work with you on this project, and we wish you all the best as you continue this case forward, since it's so important to the industry. We're all pulling for you. So thank you again for being in here. Really appreciate it. And everybody have a great day. Thanks for joining us.
Thank you.